All right. The last proposal that I see on my list, at least, and I may have missed some, so I'm going to ask at the end if there were others that came up, was to update the definition of gangs. This is gang enhanced. So it's very, very complicated as to how one gets a gang enhancement and how that's proved up. I'm going to oversimplify here, but the definition of a criminal street gang that would qualify for enhancement is if the defendant is associated with total of 3 or more people, that someone within the gang affiliation has committed more than one offense within the past 2 years. Doesn't have, and one of those offenses could be the current offense. And again, there's empirical numbers that we should try to find that may be quite difficult, but there seemed to be some interest in trying to distinguish between the truly organized, perpetually dangerous, maybe not perpetually dangerous, but gangs in the true sense of the word versus a group of friends or cliques or crews that are just a couple of people that might limit this enhancement towards targeting the activity that we are most concerned about. And of course, remember, this is on top of the underlying offense itself. We're not saying that, right, these begins with the crime, which deserves punishment. So for the enhancement piece. So I was wondering if there was thoughts or interest in thinking about modifying or updating the definition of what a gang is.
Yeah, I wonder where they came up with 3 or more. That seems like a pretty low threshold just in terms of the number. And the rest of the statute defining the gang seems to be pretty vague. So I don't have any ideas as to how to tighten it up, but those are the first things that came to my mind when you read the definition.
And I had realized yesterday also that the defendant who's getting the gang enhancement does not even need to know the people who committed the other offenses in the gang, and those people don't. There doesn't need to be any actual direct affiliation between the two people in the same organization. Again, this is very difficult to draft. Before we get into the specifics, it seems problematic. And again, we don't know empirically how we can think of the edge cases, the problematic cases, and it'd be good to know how often those are used. But it did raise some flags for me, certainly.
Yeah.
I would say absolutely we need to work on the gang enhancements and the definitions 100%. I mean, I missed yesterday's in-person testimony, but I'm sure they the racial disparities and who is considered to be a gang, right? All of those things. And it's so deeply problematic that my answer to your question, Mike, is yes. How we do that is a different thing.
And the public, and I, I'm going to keep on being a broken record here. First of all, it's 92% song of folks who receive gang enhancements are people of color.
Yep.
Which is staggering.
Yep.
But I'm going to be a broken record also on the public. Let's see if we can estimate the public safety impact here. Does this have a public safety impact, positive one? Or not, if it's completely illusionary. We talked about the deterrent effect, and everybody, even the prosecutors, seem to agree that the deterrent effect, the marginal deterrent effect of the gang enhancement was probably non-existent.
Right. I'm sure you talked about, children are on, like kids, right, are on, like, yes. I'm talking about 3-year-old kid, things like that. Like the whole issue is a disaster. So
I'm having a hard time answering your question, Mike, because fundamentally I just have a problem with it in its entirety.
Yep.
Especially now, I'm in LA. I got a report that said that there are 9 gangs in the sheriff's department. So as I'm listening to you talk about the criteria, I'm thinking about that.
Yeah.
You know, I'm thinking about, you know, the client someone had who was 16, whose cousin was, you know, the cousin is in a gang. He doesn't hang out with the cousin, but he knows the cousin. And so when he gets stopped, you know, the threat of the gang enhancement is levied on him. So I don't know that I even want to engage mentally in trying to parse it out to figure out how to thread this needle. I think just on the whole, on the strength, it's time that we do away with it. I don't trust the database. I don't trust who's in it. I don't trust how they're on it. I don't trust how the information is used. I don't trust it. I don't like it. I don't want it. And I don't think other folks do either. If that's the only thing you have, then you have got to go back to the drawing board as a prosecutor. I cannot believe that this hardened criminal gets arrested and the only thing you have is that they're in a gang, right?
You're here, 100%.
So I just can't even get into this.
On board with you
You
completely.
feel strongly about that.
Could you hear my
Sign on.
equivocation? I can't.
And for very good reason. Part of my parsing is because this is past, you know, and again, I'm ignoring Senator Skinner's advice from the top of the hour about what was passed by voter initiative and what was passed by the legislature. I'm trying to figure out things that we can practically do. One of the things that I was not aware of, and Tom, I don't know if you have the data at the top of your, is this is a kind of a relatively new phenomenon, is gang enhancements, and what states have them and what states don't, and how California is compared to other states. Do you have any?
Well, that would be very helpful to have. And what states may have gotten rid of them. And I want to go back to a point that, I don't remember who, well, of course, Sydney, you brought it up, but in the discussion with the, I think it was the DA from Fresno. Was he from Fresno?
Dr. Rosen.
He's not Rosen, the other one. But anyway.
San Joaquin County.
San Joaquin County.
So, you know, if Brown were still on, he would talk about that currently within our prisons, one of the worst, most violent gangs is the Aryan gang, is the white gang. Mm-hmm. And now how dominant their reach is outside of prison. You know, I don't follow gangs and such, but the fact that, I mean, part of what we are experiencing in this, you know, is having far more people of color getting the gang enhancement is just the over-policing of our communities of color. We know that there's a very significant involvement there's a huge increase in, say, white membership in white supremacist organizations. And why many of those are not also defined as gangs, given that at least when they show up, say, for, you know, at protests and such, they function and appear the same as gangs. So I think if there is some, we don't need to do this research, but it would be nice to see if there's some research that kind of helped expose that there are multiple other gangs, but that our gang law ends up only applying to certain, and that might help us in terms of framing this.
Senator Skinner raises a good point. As you were talking, I was thinking about some folks who I know who are actually in Aryan gangs. Their charges have been drug charges. But I don't know, and I'm going to ask to see if charges, that's right. And I suspect, based on the things that I've heard, that it's not. It's just focused on the drug charges. My second question, especially given this time, is Black Lives Matter a gang? I mean,
Yeah.
Do you know what I mean?
That, what I was thinking also there's plenty of peer rehabilitative organizations. I'm on the board of the Anti-Recidivism Coalition. They've all committed crimes. They've all committed serious felonies. We have T-shirts. We have a name. You know, if I go out and commit a crime, am I associated with their gang? Tom, do you have the other state data handy?
Excuse me.
Yeah, you with your mouth, Phil.
I mistimed that.
I don't, but Ms. Romo said there's a website that has it. I'm going to follow up with her. And there's also studies on the how many white people are in gangs, and I think it's, she said it yesterday, it's equal when it comes to self-reported membership as non-white people. So it's, you know, there's definitely data out there. I think it's also worth, you know, Mike, you said this is a relatively new thing. I don't know if it is. I mean, it was passed in 1988, so there's been lots of information about it, and there's two data points worth sharing, I think. First, and I shared this with you earlier, Mike, is Bill Lockyer, who was a legislator at the time, future AG, said that the law would be laughed out of court when it was passing. It obviously wasn't. It's been expanded since then. And the second thing is part of the original STEP Act, the Street Terrorism Act, was the LA District Attorney's Office supposed to do a report about gang culture and the impact gangs are having on things. And they did this report, and this all comes from Ms. Romo, I won't take credit for it. They did this report, and it basically contradicted every finding that supported the passage of the STEP Act, but you know, that didn't result in any changes. So I think from the start, this law has been vexed, and it just has managed to, you know, be here with us this long. And if you look at the recent California Supreme Court decisions, they're extremely long, interpreting like one word in the statute. There was this Prunty decision a few years ago that's all about the word association. 40 pages, very fractured decision. So it just, you know, I think from you can look at multiple perspectives and see that there are big issues with this law, however you want to look at it. But at the same time, sure, the prosecutors will tell us it's an essential tool that they need on their day-to-day basis, a lot of them.
Well, so the LA report, does it talk about the public safety impact of the?
I don't think so, because it was part of the original passage of the law, so I don't think there would have been enough information. And the other data point, and this came up a little bit yesterday, in 1992, I think there was a study of the gang database in Los Angeles that said half of the young Black men in the city were in a gang. So just, you know, these aren't new issues, I think, and
well, the public defender said it's even pre-Rampart. So,
right.
I mean, we know why this was designed, right? Okay, it was to stop Black and brown gangs. So we just need to put it out there, and we just need to ask ourselves if that's the policy that we want to continue to, you know, promote. But if you can have,
go ahead.
No, I was going to say, but when you have, you know, folks with H8 tattooed on their neck, you know, and they're trafficking meth. And, you know, so H8 is the Heil Hitler, and you know that they're in a gang, and they have multiple drug charges and not one with a gang enhancement. You have to ask yourself, you know, what's up with the discrepancies, the racial discrepancy? I mean, you just have to put it out there.
Well, you know, I've said it a couple times, 92%, you know, that's just almost speaks for itself. All right.
But just back to Sydney's point, it helps us just saying, oh, this is disproportionately used on Black and brown people. It's like, that's kind of now we say it. We have to still say it. But to be able to have data on those folks who have gotten the type of charges that Sydney's describing, that have markings that would indicate they're also gang, who did not get a gang enhancement, that helps us in a concrete way.
I agree 100%. And I you know, I think that we should also look at the public safety impact or lack thereof, which I suspect, again, will be telling to us. Anybody else have any more comments on this particular issue? Okay, those were the sort of discrete ideas that came up that I had on my list. Were there others that came up or either were inspired by conversation yesterday? This is not the end all be all, but I was wondering if there's anything else that we should add to the list. All right, going once. Now it comes to the point where to prioritize for further research. So we've talked about many different ideas. I have one, two, three, four that at least sparked the most conversation amongst us. So I'm going to nominate them as being the ones that require further research. I'd like to hear what other people think about it. They are in no particular, just in order of the way that we discussed it, was the Estes robberies, aggravated shoplifting issue, guided discretion under 1385, applying reforms retroactively, and gangs. I have question marks by the guns, the 1020 life, and the GBI definition. Those seem to be cusp issues, but the four that seem to jump out to us the most, again, the Estes robberies, 1385, retroactive application of reforms, and gangs. Were there others that think deserve to be labeled priorities?
I think that's a good list.
Yeah.
Okay, I'm not sure this needs a vote, but I'm just going to take a quick vote. So we're going to use those as the direction for staff to do further research and development on those four issues. I make a motion for that.
Second.
Any opposition? All right, so we're going to formally move to have those be the recommendations for the committee to do further exploration. Assemblymember Comlager, were you listening to that?
I was also making sure that I could pick up my pet from surgery.
Oh, okay.
Oh.
I hope he or she is okay. All right.
ACL.
Was there anything else? Oh, geez. Was there anything else that you wanted to add to the list?
Nope. I think that was comprehensive.
Excellent.
Can I ask one question? I understand the gang issue to be holistic, not just limited to the non-initiative things. So we'll look into the public safety and sort of some of the racial disparities further, which
I think it goes everything from
relevant.
from the misdemeanors to the definition, eliminating altogether disparities,
Gotcha.
the definition of gangs. How might we have creative solutions here that address the serious concerns that I think we all share that stem primarily from the disparate racial, disparate is not even almost complete.
Yeah.
I mean, 92% almost universal racial impact.
It's a moment where lawyer talk doesn't work. Disparate's not a good word.
So I wanted to clarify, I know I sounded confused on the 1385 conversation. But I think what I was trying to say was that my understanding is that there's probably more than one aspect to it, so that you could dismiss, but then you can also refile.
In another case, yes.
That's right. And so it's not adjudicated. So that was, I think, what I was talking about having more than one bite at the apple.
Absolutely. So 1385 can be used to dismiss a case outright, and that's exactly right. We weren't focusing on that at all at this point, but that's right. A whole separate body of law, and when that's used. But that's absolutely right.
Right. So maybe that can also be part of if we're saying maybe more guidance to kind of think that out too, right? Because you could dismiss a charge, you can also dismiss a case. But then if you can refile, then it kind of keeps going, right?
I will just conclude this, and then we'll take a 5-minute break to get to our old business, and say that we haven't talked about the biggest enhancement in terms of that's use in California and its impact on the prison system, which is the 3 strikes law, which of course not only involves life sentences for nonviolent crimes, but the major impact, the bulk of the use of the 3 strikes law is in the doubling, is in the 2nd strike sentence. I think close to 30% of people in prison in California are serving an enhanced sentence under this law. We avoided the conversation largely because of the initiative question that we have been talking about. So it's obviously near and dear to my heart. And I think I just want to note it that remains a substantial problem when we're talking about enhancements. All right, with that said, let's take a 5-minute recess. I see it's 11 o'clock. Let's get back at 11:05 to go over old business. Thank you. All right, I'm going to bring us back into order in a second. If people could turn on their videos, it'd be great. Can people hear me?
Yep.
Okay. Okay, in the interest of time, I'm going to proceed. Justice Marino and Senator Skinner, I hope you can join us quickly. This is the part of the meeting today where I'm going to turn it over to Tom for an update on the research and that he's been doing on proposals that we've discussed in prior meetings. And again, the ultimate idea here is that we want to continue to winnow down and boil down ideas for our ultimate recommendations come January. Obviously, there's going to be good ideas left on the table. That doesn't mean that we can't come back and revisit them, but we want to try to boil down our, our top priorities as we go over the course of the year. So, Tom?
Yes. So it was a long day yesterday, and I know it's we don't want it to be a long day today. So I'm going to go quickly, but if I go too quickly, obviously, please let me know, and anybody feel free to interrupt it at any time. How does this screen look? I'm doing a little bit different. I want to make sure it looks good.
It's okay.
Okay. There's a few charts, so if they start to get too small, let me know. So I'm going to go quickly, give summary updates on a few things, including 3 quick legislative updates, and look at 3 proposals a little bit more in depth. So that's what's on the agenda. So the first one we already spoke about, it's financial incentives. I won't get into this at all, but it's something that I'm continuing to look at and speak to people about, including looking at what other states have done, where you're really looking at outcomes, measuring certain outcomes, and giving rewards based on those. The second thing is something to do with these short sentences that we learned about at the last meeting. Just to refresh you all on the facts real quickly, the average length of stay in CDCR is approximately 3 years. So that's people who get out, that's the average amount of time they've been there. And 37% of everyone coming in with a determinate sentence is going to be there for less than a year. So you go from less than a year to 3 years, and you're going to cover almost everyone who's getting out. And then the intake cost alone, so this is the reception centers where people go to get evaluated for medical, mental health, and their other needs. That adds about $20 million to the budget annually, and that's on top of housing, medical care, everything else. Now that's all of intake, not just these less than a year people, but that's the amount of money that we're talking about. So this might be related to the financial incentive idea earlier, but this is something I'm continuing to look at. And obviously, if anyone has any questions or ideas for either of these things, let me know. So we'll get to our legislative updates very quickly. There's 3 here. One has to do with the misdemeanor diversion that we first heard about from Judge Lowenthal. It was passed in AB 3234. A few quick details about it. The period of diversion is going to be 2 years or left. Some misdemeanor defenses are excluded, and you can see them there, some child abuse, domestic violence, and stalking offenses, and it's waiting action by the governor. I don't know if anyone has any intelligence that would be appropriate to share, but that's my understanding of the current situation. Similarly, we talked about the length of probation terms, and this was AB 1950, sponsored by Assemblymember Kamlager. Of course, that also passed in the legislature and is awaiting action by the governor. Felony probation limited to 2 years, except for violent offenses, and a few other exceptions, and misdemeanors limited to 1 year. So lots of progress there on 2 ideas that we've spoken a little bit about here at the committee. And the third one has to do with something that Judge Espinoza asked about at the last meeting. This has to do with record relief, sealing, expungement. Those words are all very terms of art, so I think record relief is a good way to think about it. The most recent action worth talking about here was AB 1076, which was passed last year. Its effective date was supposed to be, I believe, January of 2021. It was recently delayed to July of 2022. It needs to be funded, I believe, for the Department of Justice to do what the bill talks about, which is automatically sealing conviction and arrest records in some situations, including people who successfully complete a probation sentence. I know that was the situation you were perhaps most interested in, Judge Espinoza. And that's only going to be for arrests that occur after January 1st of 2021. So again, it's not retroactive, so to speak. It's prospective, but could be quite significant when we get to that day when it's actually in effect. So that's the legislative updates and the summary updates, and I'm going to move into things a little bit more in depth. Anybody have any questions or anything up to this point? Happy with the speed? So we'll slow down a little bit for these. And I just want to talk globally what I'm picturing as what the staff next step for some of these will be. If the committee comes to a consensus around any of these ideas, I think what I would like to do is reduce them to sort of one-page summary. Here's the deal, here's some background, here's the sketch of proposal, and share those with folks who might be able to give feedback, tell us what we're not thinking about, other directions to go, and to sort of get the benefit of folks who've been thinking about this stuff. So that would be my next step, if that sounds okay to everybody. The first idea is something that we haven't spoken about directly, but it arises out of what Judge Lowenthal told us about sort of misdemeanor cases in general. And this is reducing what are called woblettes, which is a term I'll explain in a second. I don't like that it's gendered, but that is the term that is used in common parlance right now. Maybe part of our job can be thinking up a better term for these things. And there are some very common ones that I think are worth taking a look at. So a woblette in general is an offense that can be charged either as a misdemeanor or an infraction. So California has things that we call wobblers, which are things that can be charged as misdemeanors or felonies. We talked a little bit about this in the gang enhancement context. That's what the gang enhancement can do for a misdemeanor. It allows it to be filed as a felony. But if you go down a step, you can talk about things that can be charged as a misdemeanor or infraction. The big difference being, well, there's lots of differences, but infractions you can't be incarcerated for, you don't have a right to a lawyer for. They are simply, in many ways, not as serious, even as a misdemeanor conviction. So to really start thinking about this and the impact and the scale of the problem here, I think it's worth looking at this chart here. Now, this is all filings in Los Angeles County over the last, roughly 9 years or so. And what this includes is all the traffic cases, all the infractions, all the misdemeanors, and all the felonies. So this big green bar here, those are your traffic infractions, obviously the vast majority of filings. These blue ones are traffic misdemeanors. Then you have your non-traffic infractions. Orange is non-traffic misdemeanors. And then this black bar at the top is the felonies. Now we can see that these are all, everything is going down. But the thing that's going down the most is this blue bar, which is the traffic misdemeanors. And if we zoom in just on misdemeanor filings in general, and I shared this chart at the last meeting too, but I didn't break it down into this traffic versus non-traffic distinction. You'll see that, again, the blue bar is the traffic misdemeanors, orange is non-traffic, all going down, but the blue bar is going down a lot faster. It's the thing that's dropped the most in Los Angeles County over this period of time. Everything has dropped, but this one has really outpaced it. So why is this happening? Why are there less misdemeanor traffic filings happening? I've heard two explanations that I think are relevant, and obviously these are just sort of guesses. I don't have any sort of rigor or anything that we'd want to share with Mia or Steve Raphael, for example, and be proud of. But these are things that I've heard. Is one of the big traffic misdemeanors was driving without a license. In 2015, we expanded who could get driver's license. So if you didn't have documented immigration status, you could still get a driver's license. So there are simply more people who have driver's license who didn't have them before. So that might explain part of it. And the second has to do with a very common offense, driving on a license that's been suspended because you didn't pay a court fine or you didn't appear in court. This law also changed in 2018. Your license could no longer be suspended if you didn't pay a fine, which is a good change. It wasn't made retroactive. And as we'll see in a second, there are hundreds of thousands of people who may have had their license suspended under the old law. And this change in the law didn't necessarily apply to them. Now, both of these offenses are in this woblette category that I talked about. So if you're the prosecutor in charge, you get the paperwork from the police, it's up to you to say this is going to be a misdemeanor or an infraction. And what happened in Los Angeles starting in around 2013 is the city attorney, who is the person who would, the office that would handle these and the incorporated parts of the county, said, our general policy is we're not going to file those two offenses as misdemeanors anymore. They're going to only be infractions. So that might explain why you're seeing less traffic misdemeanors. And Santa Clara also recently announced a similar policy just for the driving on a suspended license. There may be other district attorney's offices that do this. Those are the two that I'm aware of and obviously are quite significant. So if we go back, I think there's one more chart after this, don't worry. If we go back to looking at the filings here, this is all traffic filings. So blue misdemeanor on top and the green infraction on the bottom. And you see everything's going down, but that blue bar is getting a smaller and smaller percentage of overall traffic filing. So if you think, okay, there's a policy that said when it comes to traffic cases, we're gonna file less as misdemeanors, more as infractions. This is what you're seeing happening here. So we're seeing less misdemeanor filings happening overall in traffic court. And I want to talk about, some more numbers, some of the impact here. As of March 2017, more than 500,000 people had a license suspended for not paying a fine or not appearing in court. In particular in Los Angeles County in the last 2 years, excluding 2020 for obvious reasons, we're looking at tens of thousands of people are charged with this thing, even under, and we don't know, or I don't know how many are infractions, how many are misdemeanors under the new policy. But we're talking big numbers, and we're talking about misdemeanors that people can go to jail for, they could conceivably be arrested for. I don't think that's going to happen too much, but it's a criminal conviction, and we're talking about making those infractions, which for most purposes don't have that those same consequences. And two other things to keep in mind. As I said, the law changed in 2017, effective 2018, I believe, that you can't have your license suspended for failure to pay a fine, but plenty of people, that 500,000 number, includes plenty of people who, if their license is going to be suspended today, it couldn't be, but that law wasn't retroactive. So lots of folks out there with the suspensions under the old law. And an appellate decision in June said, the DMV simply was not getting the right notification from the court to be doing these suspensions at all, even in the cases that they're permitted to do it, I believe. So there's serious issues with these suspensions in the first place that have happened. So that's the background for it. So I think the proposal here, and the last very important thing is this is not about unsafe driving. You can have your license suspended for reckless driving. That's a different statute. You can have it suspended for, driving under the influence. That's a different statute. This is really just these administrative things that perhaps are wrong in some sense, but they aren't related to being a bad driver. So it's not as if, it's related to what you would hope, a misdemeanor traffic thing would be, which is to encourage better driving and safer driving on the road. So I think the proposal is pretty simple. It would be to say, instead of having these offenses, which again are driving without a license and driving on a license suspended for failure to pay a fine or appear in court, instead of allowing the prosecutor to decide if those should be misdemeanors or infractions, they're infractions, full stop. And you will take, many thousands, I believe, misdemeanors out of misdemeanor dockets and make them infractions, which are, as we saw, extremely busy already, but you will reduce the consequences for someone who is in this situation. So that's the background on that. Does anybody have any questions, thoughts?
Tom, Justice Moreno, are these infractions even now currently just being handled administratively, like not even going to court? I think that's the situation in Los Angeles.
Judge Espinoza may have better insight than me, but I believe that's an option, that you can essentially just pay the fine and you don't even have to go to court. You can pay it remotely. And then if you want to
just have some kind of administrative hearing. Not even in a court. I mean, that would reduce the caseload that these cases take up in court, actually. So I don't know if that's just in LA, but I know that a lot of these things are handled administratively as it is.
I don't have an answer to that question. My understanding was that, for example, at our Metropolitan Courthouse in downtown, there are a significant number of infractions processed through there, traffic infractions. I don't know. I don't know for certain.
Yeah. I just know that down here on 2nd Street, down 2nd and Broadway, there's some kind of traffic resolution place for, I thought these things didn't even go to court anymore.
That's the city attorney's. I know that the city attorney's office has a parking infraction.
Okay.
You have a bunch of parking tickets, you can go there and
Yeah.
work it out. But I don't know about other types of infractions. Wouldn't be hard to find out.
Yeah.
I have a substantive question. Do we care? So we've lumped together failure to pay, suspended license for failure to pay, and then suspended license for failing to appear in court. I think the financial one, I think people probably, maybe there's less controversy about. My understanding is that there's more resistance to limiting this to the failure to appear, that is sort of an important civic responsibility, that courts feel disrespected, or it's a larger offense. I was wondering if people had, I don't feel that way. Again, I want to emphasize these are not safety related. I don't know if the judges or others have feelings about that.
Yeah.
Well, let me just say that, and I'm not sure this is responsive to your question, but a former student of yours crafted a program in Los Angeles County that was a collaboration between the city attorney and the district attorney's office, where 2 million tickets that had gone to warrant on infractions, quality of life tickets, that were 5 years, I think it was 5 years was the cutoff, were just dismissed, recalled from the system and dismissed. And the court obviously was a participant in that program, obviously, because they had to find all that stuff.
You're making me proud.
Yeah, well, you should be. It was a big deal. Your student was cross-designated as a DA and a city attorney. And so it was a big deal. And I think that's sort of, those things should be happening more and more often in more and more places. But at least in Los Angeles, there's leadership on that issue.
2 million?
2 million, more than 2 million, like 2 million, something like that, were just simply called out and dismissed.
Justice Moreno, do you have a feeling about this failure to appear as being more serious?
Yeah, I mean, I kind of agree with you. And, if it's just a failure to appear, what happens is that, there's money attached to this and issuing the bench warrant, and then this is a reason for taking someone into custody. They'll spend a few days till they get to court. And it's all about a failure to appear back when. And it might be even related to failure to pay.
Mm-hmm.
So it just seems that the costs associated with these warrants for basically minor offenses really adds up to a lot of money and clogs up the system. So.
And there's a direct correlation between who has these outstanding warrants in the system with poverty and homelessness.
Yeah,
there's no question.
Yeah.
So.
All right, I think we like this issue and want to continue pursuing it.
Yeah, and at least in the old days, someone might have 3 or 4 warrants. They'd have to go to each courthouse. I think they eliminated that. But you remember that? And they'd be in custody 3 or 4 days. And just think of the transportation costs, everything else of keeping a person in custody for these traffic warrants.
And the not to mention the disruption on their lives, their families' lives, jobs, housing, all the collateral consequences.
Yeah.
Okay.
All right, I'll keep looking at it. And I will say this, there's a lot of activity around, license suspensions and these essentially what are crimes of poverty many times. So I think we'll be able to hook into a lot of that. And, the people who are litigating that case I mentioned against the DMV, it's a big coalition, of folks who I'm sure have lots of data and perhaps some more ideas and ways to make this strong. So I think it's something we could build up relatively quickly and there'd be some enthusiasm for. And Mike, you said it too. I think the fact that it's really not about unsafe driving and just about bureaucracy makes it particularly broadly appealing to a lot of people. Okay, great. Well, I'll keep chugging on that one. Let me share again. All right, next idea is probation. Again, this is about eligibility. So we spoke about this last time, and we're gonna, I think, be able to have a bit more of a detailed conversation about, you know, specific offenses or type of offenses that it might make sense to speak about here. So just to give a little more context, this is a chart of dispositions and felony cases over the last few years. So that big giant gray bar, that is obviously the most common disposition, are what are called split sentences. So that's a combination of jail and a probation sentence. Blue here is felonies, or I'm sorry, is prison sentences. Orange is straight probation, so where it's not split with a jail sentence, so may still include some period of incarceration. Yellow is straight jail, and then we have our fines here. So we can see everything has gone down, less cases, and this is sort of post Prop 47 too. So I think that's, you know, important to keep in mind for some of these. Just some specific takeaway from those numbers. Straight from 2014 to 2019, so sort of the start and end of that graph, 5-year period, straight probation decreased from 15% of dispositions to 7%. So it cut, you know, roughly in half. Split sentences went up a little bit, and prison increased a little bit too, though it also came down a little bit. And straight jail held steady at 12%, all of which is a way of saying there appears to be less straight probation sentences that are given out compared to these other dispositions. Again, that might be because it is post Prop 47, so perhaps some of the less serious cases have been removed from the system, so we've concentrated the seriousness, but that might be one explanation. So I want to give just a very quick background on what the law currently is. So for most offenses, probation is available at the discretion of the court. As we've talked about, that discretion is essentially totally, you know, up to the court. There isn't much guidance there. There is a category of cases, the second bullet here, of offenses where probation is presumptively unavailable, and I have a few examples I'll show in a second. And of course, there's a third category of cases where probation is simply not allowed no matter what. There's essentially a mandatory minimum of incarceration. And what I would suggest adding or changing here is this first category. Instead of probation being available at the discretion of the court, we would say probation is the presumptive sentence. You put a little weight on the scale in favor of probation. Of course, it can be overcome, and I can talk a little bit about how that might work as well. So just to ground us a little bit more, here are some cases where probation is presumptively ineligible. Any burglary of a house and inhabited dwelling, failure to register as a sex offender. If you have 2 prior felony convictions, your new felony, you're presumptively not going to get probation, some sex and some drug offenses. And the usual language you see here is that probation shouldn't be granted except in unusual cases where the interests of justice would best be served. So pretty open-ended. Some examples of where you can't get probation at all: a robbery where there was a gun or great bodily injury was caused, so tying into our discussion a little bit earlier about those enhancements. And if you're on probation or parole and you are facing a new serious or violent offense, probation is ineligible. Though I will say what I've heard is this is well, actually that will come up in a second, sorry. And then if you have a prior strike, any felony you're facing now, you're supposed to not get probation. This is one area where I've heard where 1385 is a common way to reach a disposition where probation might be eligible if the prior strike is sort of not used for that situation. And then there are other drug offenses where you can't get probation, though all of these drug offenses are 1170H offenses, which means you would go to jail, not prison. And there are lots of offenses that are eligible for probation that are prison offenses. So there's just sort of this disconnect between, you know, what is available for each type of offense. There doesn't seem to be any great theory behind, you know, how these different things are categorized. So what would this presumption do? It would say probation is the presumptive sentence for most offenses. Judge always has the option of denying, but the burden essentially is now on the prosecutor to say why incarceration is appropriate instead of the defendant essentially have to say why incarceration is inappropriate. It's a way of putting into the penal code that incarceration really should be the last resort, absolutely available as an option, but encodes a little bit, I think, of some of the ideas that the committee has talked about from day one, from what, you know, Craig Haney told everyone about, this sort of idea of parsimony, that incarceration should not be the default. It should be something that, you know, has to be shown as appropriate. And South Dakota has a presumptive probation scheme, and the presumption can be overcome with this language that I have here, which is, if there are aggravating circumstances that pose a significant risk to the public. So you can imagine something similar that would give some guidance. Of course, we could be more specific too, but that's sort of, I think the two elements of a proposal like this is that, probation is presumptively the sentence unless, X, Y, and Z. And this would keep in place the existing, decisions that have been made about things that are ineligible or presumptively eligible. And of course, that's the next thing we can talk about is about whether some of those should be changed. But to get back to what offenses does this apply to? Where do we draw the line? So there are, I came up with this sort of taxonomy, and it looks more complicated, I think, than it is, but I think there are essentially, five places we could draw this line, or six, I'm sorry. You can start with misdemeanor. So every misdemeanor, the sentence is presumptively probation, which if the AB 1950 comes into law, that means the probation term is 1 year. I think most misdemeanor jail terms are going to be significantly shorter than that. So you may have people who say, you know what, I'd rather do the 10 days than have to deal with probation for a year. So that, is a little complicated there. The next category of seriousness up are wobblers, which, we spoke about when speaking about the traffic offenses a little bit. So these are things that can be charged as a felony or a misdemeanor. For example, theft over a certain amount is a classic wobbler. So you can sort of say every wobbler presumptively probation is a sentence, or you go up another notch and you talk about these realigned offenses, which is the Penal Code 1170H offenses, which say if you're going to do incarceration for this, it's going to be in jail. By definition, these are non-serious, non-violent, non-sex offenses. Drug sale, common, very common example of an offense here. Next level up, non-strike offenses. So these are things that are not serious or violent, but that you may go to prison for. For example, if you have a drug and a gun, that's not a serious or violent offense unless you use the gun. But just having these things in, your apartment or whatever, that's going to be a non-violent offense. But you have to do that in prison because it hasn't been realigned to jail. And then you get into the more serious offenses, non-violent offenses. So these are things that are considered serious but not violent. Example here would be gang enhancement is added. That makes the case serious, and you'd have to go to prison for that. And then finally, you would just have all offenses, which would include violent offenses, things like robbery and above. So those are places we could decide to draw a line. You could sort of say, let's do everything, leave, and things that are already prohibited from having probation, all those prohibitions would stay in place. Or we could talk about modifying those further. But this, I think, is a sort of helpful taxonomy of places where you could sort of decide. So that does bring us to talking about adjusting some of these choices that have been made for the presumptively ineligible and ineligible offenses. These are the same examples that I just had, but just to refresh, to me, burglary of an inhabited dwelling, that can be an extremely serious offense, or they can really range in how it's committed, and to just sort of treat that as an offense where, well, you're unlikely to get probation for that. It seems like there might be some room to adjust that. Same as failure to register as a sex offender, that can sort of be a relatively innocuous situation or an extremely serious one. And the same thing for a defendant who has 2 prior felony convictions. I mean, if these convictions are very old, very minor, things that perhaps wouldn't even be felonies anymore, you can imagine there's just such a range in how these things can happen that to make these broad judgments might be inappropriate. And same with some of these ineligible offenses. So, if you have any prior strike, you can't get probation anymore. That certainly probably is appropriate a lot of the time, but seems like a harsh rule otherwise to have as a starting point. And same thing with these drug offenses and perhaps other offenses where they're jail offenses, but you can't get probation for them. And meanwhile, you have prison offenses where probation is available. It just doesn't seem like there's a lot of coherence there. So I think that leaves the 2 questions for the committee. First, is a general presumption seem like something we want to continue to pursue? And if so, where do we want to draw that line? And second, do we want to continue to look at adjusting these presumptively or totally ineligible offenses. So questions or thoughts, or I can keep grooving.
We have data on how many cases fall into the categories that we've discussed, that you've discussed.
Not precisely into those categories. I have, let me see what you know, we have these categories that we see, these very general categories: violent crimes, property, drug, and then everything else. So, you know, as we saw, the drug offenses, that those don't sort of map neatly onto those. But certainly the violent property part of it could be helpful.
And there already seems to be some sort of normative presumption in favor of probation. I mean, probation is a very common.
Right.
So I don't know, by codifying what's already been in practice, does that achieve, what does that achieve?
Well, I think it's the point you made earlier about plea bargaining, Mike, where it sort of, you know, lowers the ceiling, or, you know, not, it's a presumption, so it doesn't lower it, but it, you know, it
Softens it.
Yeah, it softens just the numbers overall. So I think it would, you know, have that sort of trickle down economics effect. Unfortunately, might be the metaphor, but no, it's a very good question. And, you know, and that dynamic might change in the future too.
Exactly.
So, you know, we might, in 10 years, those probation, that split sentence bar, the blue bar might be a lot higher, for example. So there might be value in just saying, you know, this is a value that people seem to have now, which is incarceration should be difficult to get. And one way to say that is, you know, we're going to presume that a non-incarceratory sentence is the way to go, unless, you know, it isn't.
I totally agree. That's what I was going to say, exactly what Tom just said about codifying it, even because practices change all the time, right? As the situation in our world changes, and it sends a strong message to have it codified in terms of prison, jail is a last, incarceration in general is a last resort. So,
you know, I'm in general agreement with the thrust of what you're saying, but I think the devil is in the details.
Right.
I mean, that was a lot of information. I just would have to consider this in more depth and detail and getting the data. And, you know, I would hate to go in, you know, with a sledgehammer and apply that general principle to some of the offenses that you've kind of listed where it might apply. I mean, that's a lot to chew on.
Right.
So I feel, I don't know what the objective here. I agree with the overall objective, but what are you asking of us at this point in time?
Well, I think I totally agree. It is, I mean, a very expansive universe. And I think the objective would be to talk to, you know, for example, the probation officers of California, prosecutors, defense attorneys, and other folks, and sort of say these questions about, well, A, would this, you know, what kind of impact do you think this would make on current practice? And B, where should this line be drawn? Are there other ways to think about it? Because those categories I came up with are just, you know, the things that seem apparent to me, but there might be a better line to draw too.
Right.
And to look at other states as well. That's also something that's happening. You know, for example, Illinois, their sentencing statute says, you know, probation is the sentence unless, and then it lists similar things.
Right.
The one thing I'm trying to figure out is, does that mean anything, or does it function like every other state where incarceration is actually sort of the default most of the time? And you know, what does that statutory language mean? I'm sorry.
Is this a long-term inquiry? You're not asking to have some kind of resolution by January on this, are you, or Michael?
By January, yes, I think that we'd hopefully have some kind of proposal. Now, it's not I'm not saying that we're gonna fix probation by January.
Oh,
And we
no.
might say, And we might say that we haven't ironed it out sufficiently that it makes the cut by January. We have a lot more than, ideas, but the question I guess for today is it worth continuing to research, or is it too much of a hairball that we should put it aside? And if we do continue to research, where are the areas that we would continue to research?
Yeah.
I think that's the question for today. We are not voting. And Justice Moreno, if your feeling is this is too much of a hairball for us to possibly unpack by January,
Yes.
then I would say that maybe you would suggest that we table it, but others might say, no, let's continue to try to unpack it. So yeah, Dean Richardson.
Yes, so I wanted to respond because I think this is a great discussion, and I guess for me, I don't want to table it. And part of my reason for that is if part of what we're concerned about is over-criminalization and overuse of incarceration as the first instinct. And if that's what we are attempting to change, then the reason I have no issue with the current list, as long as it is, as complicated as it might be, regardless of what the data might show, is it doesn't take incarceration off the table. So the way I view it is all it's doing is flipping our first instinct. That's it. That's the message it sends. And we know that where we start out really affects where we end up. And so we have started out over the course of decades with thinking prison, 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 jail, 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 incarceration, incarceration. All we're saying is start from a different place, right? So the presumption is probation, and then overcome it. And certainly if probation is incorrect, then a justice, a judge, a prosecutor can make those arguments, but where we start out definitely affects where we end up. And so that's part of why I'm not as concerned about what data we might be getting, especially because every case is so different from the other. And so to me, this is just, we're starting out with a different mindset now, but certainly incarceration can always be the end result. So that's why I wouldn't want to table this right now.
I'd say that my biggest concern of what we discussed were the automatically ineligible cases. It seems to be quite broad, and there might be some tinkering there, because there does seem to be a normative. Again, I appreciate the importance of codifying things, but there does seem to be already a normative presumption of or heavy use of probation, or at least split sentences. Judge Espinoza, do you have a thought on this?
Well, just that I agree with you. We should be looking at the list of ineligible offenses. It's aligned with our notion of increasing judicial discretion. So I agree with Carlos. It's too soon to commit to anything, but I also agree with Dean Richardson. Let's look at it further, but let's not look at the whole array of things, because as you've indicated, 95% of, or 90, whatever the percentage is, it's over 90% of all felonies filed, at least in our county, are result plea bargains, and a vast majority of those result in a grant of probation. So I think we should continue to look at it.
Dean Richardson?
Just wanted to add, I agree with that. So just to make it clear, I agree with Justice Moreno and you, Mike, and you, Judge Espinoza, about the ones where it's not a presumption, but we're completely taking it out of making it ineligible for incarceration at all. Yes, I agree. We have to look at those much more carefully before jumping there. So just wanted to clarify that point.
So, Tom, it seems like there's consensus, and I'm going to come back to you, Justice Moreno, to make sure that you feel comfortable with this, is that we want to explore this further. We're definitely not committing to making this as a recommendation, but to make it a priority, to make it simplified and clean without maybe solving the whole problem, but chopping off or hitting some of the most obvious areas that in need of improvement, and try to make a clean, simple recommendation here, rather than swallowing the whole pill. Or Justice Moreno, am I not summarizing? Would you think that we still?
My concern was the speed and all the detail, but if it's a general kind of approach, I'm fine with that.
Okay. Assemblymember Comlager or Senator Skinner, are you there listening? Okay, without objection, I'm going to say that that's going to be our recommendation to continue pursuing this.
Great. So, right, it's another way of framing it is, you know, reducing mandatory minimums. That's what you're saying. If you're ineligible for probation, that there's, you know, incarceration is the starting place.
Yeah.
Got it.
Great. Okay, this will be the last topic, and unfortunately, the most wonky, even worse than the wobblets. But we'll get through it together.
I'm in favor of letting them wobblinos.
Okay.
Wobblitos.
Wobblitos, yeah.
Pablito.
Weeblos. All right. So we're going to talk about credits a little bit. And, you know, Governor Brown talked about that the penal code shouldn't be the tax code. And this is, you know, perhaps one of the most tax codey part of it, but also extremely important because it affects everyone who's inside. And, you know, as Mike sort of talked about when DA Rosen suggested just cut everybody's sentence by 20%, credits are sort of a way to do that if that is what someone wants to do. So the basic idea here is that you have same person in prison or jail serving a sentence is gonna get different credit in each of those settings in a way that doesn't seem to, again, sort of have a theory or a big overarching reason behind it. So just to establish some quick vocabulary, you know, there are essentially two types of credits. There are good conduct credits, and that's what you get just for basically following the rules, not getting written up for anything, and doing the bare minimum that the facility has told you to do. And in default, in both prison and jail, the default is you get 1 additional day for every day you serve. The lingo gets so complicated here, I'm going to try to avoid it, but you hear it, you know, called 2 for 1, 50% credit. But I tried to reduce everything to, you know, apples to apples. So you do a day, how much extra time do you get? So the default is you do a day and you get another day of credit. But of course, and this is the problem, is there are lots of exceptions and expansions to that. And the other type of credit is called earned credit. And this is when you get some additional time off your sentence for completing some kind of programming. This is what, you know, yesterday we heard folks talk about milestone credits and things like that. That's what this is. So if you get a GED, complete, you know, some college courses, do other programming, you can get even more time off your sentence. In prison right now, you can be up to 3 months off in a year. But as we heard about, there can be significant waiting lists. So it's not as if you can sign up and the next day you start, you know, doing your milestone class. Jail also has what are called jail milestones. That's much more limited. It's about half as much, 6 weeks in a year. And from what my sort of anecdotal research has revealed is it doesn't seem to be widely used at all. So those are the two types of things that we're sort of talking about. And the other just big picture issue is the jail credits are in the penal code. Prison credits are after Prop 57, particularly CDCR sets their own regulations on those. So it's, you know, sort of same subject matter, but two sources of authority, at least as things are right now. So I think that, you know, I tried to really think of the best way to make this understandable and not, you know, the tax code. And I thought of 3 common scenarios where you can sort of see how these differences, I think, result. So we'll just walk through those very quickly, and please interrupt me at any time or just tell me to stop talking. I'm happy to do that. So we're going to imagine someone who has a non-violent offense, like a drug sale, but has a prior strike offense. So because of the prior strike, they have to go to prison. And that's also going to affect how much credit they get. So in jail, every day they do, they're going to get 2 days of credit. So it's that default credit. But when they go to prison, they're going to get less time. They only get a day and a half for every day that they do. So the credit is cut in half. And now that's because of the prior strike. And CDCR, they look at your strike history, and if you have a prior strike, you get less credit under the way the rules are right now. But the strike has all these other effects too. It's also what made you go to prison. Otherwise, this particular person wouldn't have had to go to prison. And it also has made the sentence longer. So you get a longer sentence because of the prior strike, and you have to do more of it. big asterisk. There's also the availability of Prop 57 parole. I'm just going to ignore that because it's just going to complicate things too much. We're just looking solely at credits here. So the result here is you want to stay in county jail as long as you can because you get more time off your sentence. The more time you do in county jail, the less time you're going to do overall, just looking at credits. Scenario 2.
And I just want to interrupt here too, is like, I just keep on coming back because I was so impressed with the study that said that the outcomes are better if you stay in county jail.
That's right.
Perhaps partially because you do less time, but.
Well, you know, to continue the sidebar, I followed up with Mia and Riken. They said they controlled for that and it did not seem to affect anything. It really did seem to be about jail versus prison.
That's really astounding for a number of reasons, especially because of the lack of programming in jail and how horrific jail conditions seem to be.
Right.
But it's fascinating. Continue.
Right.
Thanks.
Right. So let's talk about our second scenario. So this is someone who has a nonviolent offense but has to go to prison and doesn't have any prior strikes. So this is someone who, when they're in jail, they're going to get that default. Every day they do, they get 2 days credit. But when they get to CDCR, they can now get more credit. If they are in the minimum custody setting and they have a nonviolent offense, they can get up to 3 days credit for every day they do. So that's a big jump. And they also get the extra, you know, earned credit, the milestones, the education, things like that. So they can really accelerate how much they get. So this is someone who wants to get out of jail into CDCR as quickly as possible, just from a credit perspective. And then the last person is someone who has to be in jail no matter what. So we take our drug sale scenario again, but this time the person doesn't have any strikes. They're going to be in jail the whole time, which means they get that default credit. Every day they do, they get 2 days off their sentence. Prison, it's just not available. I put it bright red neon because I knew it would be at the end. Hopefully it would help people wake up if this was getting too boring. But so that means they're stuck with the jail credits, but if they went to CDCR, they could earn that 3 days off for every day they did. And if they got to minimum custody, they could also get those earned credits. So this is someone who just credit-wise is going to do more time than they would, ironically, if they could actually get to jail. They're likely to do more time. So I think that demonstrates the way some of the most common differences, you know, the big one I think is if you have a strike prior, it doubles your sentence, it makes you go to prison and makes you do longer of that sentence in prison. And that's just a CDCR regulation that's requiring that. And then the fact that jails have you know, on one hand, more generous in a way because they don't look at the prior strike conviction, but they limit the amount the credit you're going to get in ways that CDCR doesn't on the lower end, on the sort of folks who have nonviolent offenses. So those are, I think, the areas where the discrepancies are most stark. There's plenty more, of course. And I think the proposal would just be, you know, those should be the same. They shouldn't be these discrepancies just solely based on someone where someone is locked up. And the second issue here is just trying to understand a little bit better about what's happening in jail with the earned credits. It's much harder, as we learned at the short sentences hearing, to imagine how programming works in that setting because historically jails were not set up to do that. It's going to cost more money, and that may be part of the reason why you don't see those sort of jail milestones used as much. But from the perspective of someone who is forced to do a sentence in jail, that seems, you know, like they're not being treated the same as someone who's forced to go to prison at the end of the day. So I think those are the two issues. One is much more of a concrete proposal. Should jail and prison credits essentially be equalized? And the second is, should these earned credits continue to gather info there and think about ways that the jail situation would be made more like the prison one? And that's it. Any thoughts or questions from anybody?
We could equalize the credits between jail and prison, but if the jails don't offer them, we haven't done a lot.
That's right. So that's where the distinction between the good conduct and the earned credits starts to become important. The good conduct is just what you get for not messing up, essentially. So that, if we just said, it could increase that and say, instead of being, you know, 2 for 1, it could be 2.5 for 1, 3 for 1. That can just be sort of increased in the penal code. But the earned credits, the programming issue, that's a little more dependent upon what the facilities choose to do.
Well, I certainly think it makes sense for the same person, the same crime. They shouldn't be serving, getting a longer time behind bars just because they happen to be in county jail versus state prison. I think it's a little bit of a tricky legislation to draft in order to make those and make sure that we're not extending. The thing that we wouldn't want to do is, okay, well, we'll equalize it by extending certain ones. I don't know how you write legislation that ties jail credits to CDCR regulations. Maybe that's just a problem to be thought out in the future. My other thought or question is, I know in LA County, for example, and again, this is a temporary problem, getting back to what we want to codify and what's, people are serving not a lot of jail time because of crowding issues, or they pre-pandemic at least. So the credit issue kind of is out the window in Los Angeles County.
I think it actually, for people who are doing the 1170H sentences, are actually sentenced to felonies. I think,
you're correct.
yeah. So yes and no at the same time.
So for the
I'm sorry,
1170H,
can you finish that sentence? Because my understanding is that the only people in the LA County Jail who are actually serving what we would expect of their sentences are the realignment folks.
Yes.
Yes.
Exactly.
Everyone else is walking out because there's no room for them.
We all agree.
Okay.
So the credits would be significant even there, I think, is what we're
yes, okay.
landed on.
Thank you. I think this is pretty common sense. Of course, I'm going to come back to it. I'd love to know the numbers, how many extra days are people serving because of this credit, disparity.
Mm-hmm.
It seems ridiculous. And you've already discussed some perverse incentives. And we want to, avoid that, certainly. And then, it also, I think, resonates with the theme that we started off today and from, Governor Brown about, to the best we can, incentivizing good behavior, rehabilitation, participation in programs, even in jails. So I think that all moves in that direction as well.
And one thing that I think I didn't highlight enough is there's equalizing and then there's expanding even sort of what the base credit is. And that was, I think, what my answer to Senator Skinner ended up saying is that there's sort of, a little bit complicated statutory wise, maybe Mike, to say, prison and credit should be the same. Whoever has the most generous ones, and look at these CDCR regulations, and that's what controls. It gets a little tricky, but I think we can find a way through it. But even just to say the default credit should be expanded from 2 to 1 to something bigger, or you can make it more complicated and have it be for certain offenses, or you earn more credit the longer you've shown you can do well, so you can sort of graduate to a accelerated credit earning, perhaps after you've shown you can do it well for 6 months, and you can earn more to really incentivize people. Because I think something that's interesting is that you get in this one category, and that's what you're in from day one to your last day a lot of the time. It doesn't matter if you have been getting A+ to whatever it would take you, to losing credit, you sort of get the same reward. And whereas if, you could increase that to really incentivize that behavior a little bit more. So all that's perhaps inarticulate way of saying there might be ways to even expand in addition to equalizing.
One of the things that I've been struck with was, especially when we talked about short sentences, is the number of people who cycle in and out of jail in California over the course of a year is astronomical, and is sometimes not talked about very much in the conversation about criminal justice reform. It's a lot more complicated. There's so much churn. Each county has a slightly different process. It's not the big LWOP sentences or 3-strike sentences or death penalty sentences, but in terms of impacting the number of Californians, this is obviously way, way, way bigger impact, and the entry ramp to many people into the criminal justice system I think it's precisely the type of thing that this committee should focus on. It's not necessarily the headline grabbing, sexy type things, but the volume of people and the impact on their lives, jobs, housing, family, etc., can be huge. So I certainly appreciate, Tom, you figuring it out. I think it's an area of expertise that not a lot of people understand. So that's my last thought on this.
Well, unless anyone disagrees, I think what I'll do is perhaps talk to folks who run jails and folks who know more about credits and see what, if I miss some, subsection somewhere that would render this moot, which would be depressing, but not entirely surprising given the complexity of some of these things, and just try to come up with something that is, concrete along the lines of just, it should be equal as much as possible. Perhaps try to talk to CDCR as well and make sure to get their thoughts too, because it would affect
and let's
them.
find out where the big gaps are and the where's the extra time being served. And I think with everything, I'm very curious about how other states and other jurisdictions address similar problems. We can't do a whole 50-state survey probably, but I think we should rely on other states.
Looking at credits in other states will make looking at robberies in other states easy.
All right, so I think that there's no objection to continuing to research and refine this idea as well. This is a good one. Again, this does not mean that this is going to be part of our recommendations. At the end of the day, we want to have really tight recommendations that we feel like have success to pass and have genuine impact. And ideas that we might be working on this year could be recommendations for next year as things develop, or we might be able just to be resources for legislators who are hungry for further ideas that we haven't fully baked, as it were, or have come to a consensus amongst us as being top priorities for whatever reason. Tom, is that all you got?
Yes, sir.
All right, I think we're pretty much at the end. Brian, I don't think that there are any administrative issues. Is that what you said?
Yeah, that's correct. The only thing that might be nice to take a minute on is if Rick Owen is still here. He's our new hire as the second of our attorneys committed to the committee. And I believe he came on and briefly introduced himself before we started yesterday. And so I don't think everyone who's with us today met him.
He's here, Rick. If it's okay to turn your camera on, can you raise your hand in Zoom? I don't want to, surprise him. Oh yeah, he's good. Okay, I'll just bring him on. He can say hello very quickly.
And Laura, I'm going to ask the same of you in a second. So.
Oh, great.
Okay, here he is. He's teleporting in.
Hello, everyone, and thanks again for having me. I'm really excited to join the group. Rick Owen, I'm currently a public defender for one more week. I have been doing so for 8 years. These 2 days have been powerful, and I couldn't be more excited to be joining the group. So thank you, and look forward to working with you all.
Excellent.
Feelings mutual. Thank you. Welcome aboard.
Welcome.
Laura, can you raise your hand if you're good to be introduced? Okay,
Yeah,
great.
all right.
So the second person that we're also adding informally to the committee is Laura Hoffman, who we got a generous grant from the Arnold Ventures Foundation to hire somebody at Stanford to ostensibly come work at my project, but at least half of her time will be devoted to policy development stuff that we're working on in the committee. And I just wanted everybody to lay eyes on Laura. Laura, will you say hello and give a brief introduction?
Hi, yes. Hi, I'm Laura Hoffman. I'm excited to work on this project too, just like Rick. I've been a federal public defender for about 10 years, and I also taught at Stanford last year in their federal litigation program. So I'm super excited. You guys are doing incredible work, and I've been watching the last 2 days. I'm really excited to get to work on this.
Thanks, everybody. So we're gradually expanding our staff. Up to this point, really, Tom has shouldered so much. Brian and Barbara have as well, but Tom, all of the witnesses have come together. The substance of all the reports has really, fallen on Tom's shoulders. It's an extraordinary amount of work. Governor Brown, as yesterday, discussed how overwhelming it is, and he's been doing it all up to this point. Obviously with our support and guidance and direction, but it's really been great. Thank you, Tom. I should also mention that Brian and Barbara have been extraordinarily helpful, especially with the administrative aspects of the committee, which are not small, especially as we're bringing people on staff. And then the data project, as I keep on talking about, the the negotiations that we've been ongoing with the various agencies in the state to get this data sharing agreement, privacy agreements, agreements with companies that will help us with the data development and analysis, agreements with academic institutions who are also likely to be able to help us do the analysis, which we're all very excited to bring on board. This is all going on behind the scenes. The staff is really working hard. I'm super proud of their work, and I just wanted to make sure that we all recognize that before the weekend. Does anybody have any final words, comments, thoughts?
Do we need to approve the minutes? I think we
Oh,
need to.
I'm sorry. Yes, so I guess
Sorry. What a counter anticlimax. That was so nice, and now.
Okay, so I hope everybody got a chance to review the minutes from our last meeting. Tom and Brian, I think, worked on them. I think they're very good, and I move to adopt the minutes.
Second.
Any objection? Okay, the minutes are adopted. Everybody, these are extraordinary times. In some ways, these Zoom meetings have added some convenience in that we've been able to meet a little bit more frequently than we anticipated, having more witnesses be able to be available to us than anticipated. In some ways, this has accelerated our ability to do work, but obviously it's extraordinarily hard times for all of us in all sorts of different ways, not to mention the people that we hope to help benefit with the work that we're doing. But also just for all of you. So anyway, I really do hope that you have a good weekend, and appreciate you, and thanks for your time. Never be a stranger. You know how to reach me if you have any questions, all right?
Thank you.
Thank you all.
Thanks.